time set for a show cause.
Okay.
As for purposes of arraignment, sir, we'll do it like this. I'll enter a not guilty.
Are you talking to Mr. Hicks or Mr. Lee?
Pardon me?
Yes, you should be able to follow the first one.
Are you talking to Mr. Hicks or Mr. Lee?
Mr. Hicks, I'm sorry.
Yep, you should be dialing area code 929.
Mr. Hicks, for purposes of arraignment, I'm going to enter a not guilty plea on your behalf and give you a $0 bond, all right?
I object, Your Honor. That would be practice in front of the bench.
It's the same process.
Say that again.
I object. That would be practice in front of the bench. Practicing law from the bench. You will have to recluse yourself if you hold.
I deny your motion. So go ahead. How do you want to proceed?
I would like for everything to be dismissed, if it pleases the court.
Denied. What basis?
You haven't even let me tell my grounds.
All right, basis. Give it to me.
For one, a ticket is a bill of attainder. Article 1, Section 9, Clause 3 of the Constitution of the United States, no bill of attainder or ex post facto law shall be passed. You can have a written assistance
All right, let me
to equity that transmitted into law penalties.
Let me stop you right there. We have, first of all, we have a problem with the transmission. You're breaking up really bad, and we can't get that on the, turn your video off. Maybe turn your video off. That trial date you want or not?
It's up to y'all. Remember, y'all make all the rules.
Trial date. You want to, let's give them a jury trial date.
Jury trial?
Yeah.
How long do I have to turn in my briefs?
I'll give you some dates in a second.
Okay. Scamming. With a smile on your face. If it pleases the court, what jurisdiction are you charging me on?
I asked the question, sir.
I just said if it pleases the court.
I know, and I'm telling you, I asked the questions. I appreciate your respect for the court, but I asked the questions. I told you to read the court rules.
All right, welcome back everyone, because today we are revisiting a familiar face, sovereign citizen Albert Hicks, but this time, the environment has completely changed. Last time we saw him, he was up against what many viewers felt was a softer judge, and Hicks managed to dominate the room with non-stop interruptions, pseudo-legal jargon, and confidence that far exceeded his legal footing. That left a lot of people frustrated. Well, consider this episode the course correction. Today, Hicks is facing Judge Perkins, a judge known for structure, control, and zero tolerance for courtroom nonsense. And that contrast alone makes this hearing fascinating. We've got 2 appearances packed into one session, multiple case numbers, and a defendant who refuses counsel while claiming mastery of the law. That combination almost always leads to fireworks. Stick around, because what starts as confusion quickly turns into contradiction, courtroom pushback, and a reminder of why sovereign citizen arguments consistently.
June the 11th?
June the 11th. So let's put your final pretrial date will be, let's see, put that a day before. That way, that'll be the date we'll argue motions on June the 10th. May the 24th will be your motion, and now May the 24th, and the city will have 7 days to respond. So the response to the motion will be due by May the 31st.
I appreciate you, Your Honor.
All right, have a very good day, sir.
This right here is where the tone of the hearing is established. Hicks immediately disputes the court record, claiming he never entered a plea, despite the system clearly indicating otherwise. This is a common sovereign citizen tactic: deny the legitimacy of paperwork while simultaneously demanding the court respect their interpretation of it. Notice how Judge Perkins doesn't argue, she simply clarifies and moves forward. Then comes the refusal of counsel. And this is a pivotal moment. Self-representation sounds empowering, but in reality, it strips the defendant of protections, guidance, and strategic restraint. The judge even frames it as his first break of the day, which is telling. The court understands that choosing to go pro se often works against the defendant. Viewers, this is where things quietly go sideways, because from this moment on, every misstep belongs entirely.
You have a final pretrial set for June the 10th. And a jury trial date set for the same day.
I must have corrected.
Okay, that's not correct.
Yeah, you did.
Hold on one second. Let's get the date straight.
I'm not here for that.
What are you here for, sir?
The slip says for Jonathan Reeves.
Jonathan Reeves.
Yes.
I don't know anything about it. Jonathan Reeves. Let's see. Maybe. I don't know anything about a Jonathan Reeves.
Well, I motion for this case.
Are you Mr. Hicks? Are you Albert Hicks?
Yes, I am.
Okay, so we're gonna get you your dates. And that Jonathan Reeves,
I already have my dates. I talked to you last week, remember?
I think it's correct.
I have June the 10th and June the 11th.
Very well. Okay, we'll see you back on those dates, sir.
But this matter right here with this Jonathan Reeves.
Well, what does Jonathan Reeves have to do with you?
That's what I'm here for court for today. I'm making a personal special appearance for this.
Okay, I don't know. Who is Jonathan Reeves? Do you know who that is? What does it say on that? Because it sounds like it may be Jonathan Reeves may have stayed at that address at some point and left. I don't know.
Here's where the legal misunderstanding really starts to snowball. Judge Perkins enters a not guilty plea on Hicks' behalf, a routine procedural safeguard designed to protect defendants and keep cases moving. But Hicks immediately objects, accusing the judge of practicing law from the bench and even misusing the term recuse. This is textbook sovereign citizen behavior, weaponizing misunderstood legal vocabulary to challenge judicial authority. The irony is thick: he demands proper procedure while actively obstructing it. And the judge's response is crucial. She denies the motion calmly and asks how he wants to proceed.
Apparently wrote the ticket.
And where?
That's good.
And that's scheduled for the final pretrial on, I see where he's here today. It says scheduled for pretrial today. But that's all gonna be handled on the 11th of, Jonathan Reeves is supposed to be here on the 11th of June, on the day.
I was not notified. 11th of June.
Yeah.
How was he going to be here on the 11th of June? And I have Spidell on the 11th of June.
You have a couple of different officers, obviously.
Jonathan Reeves and Spidell has nothing to do with each other.
Well, we're just consolidating, we're having all of
Why
them here.
why would you do that against my will? Why would you just do that?
I'm doing it because of the judicial economy, sir. So
I'm
judicial
challenging that one.
Okay,
I'm
then
not
write
with
a motion, and we'll rule on it, but it's all in the same, we're all.
This is where Hicks fully leans into pseudo-constitutional law. He invokes Article 1, Section 9, claims a traffic ticket is a bill of attainder, alleges lack of an injured party, and argues the officer didn't sign under penalty of perjury, all rapid fire, hoping something sticks. But notice what the judge does next. She points out a direct contradiction in his own argument. He claims perjury while simultaneously claiming no signature exists. That's not a technical error, that's a logical collapse. And this is why sovereign citizen arguments fail so consistently. They rely on memorized phrases rather than coherent reasoning. Judge Perkins doesn't debate ideology, she addresses facts. Motion denied.
Mr. Hicks, all I ask you to do is you can file a motion. You can put all of that stuff in the motion.
Yeah, so y'all, so you can come back and say motion denied, right? Like you did last time.
Well, if it's not, that's my discretion. If I don't feel that it meets the, if it doesn't meet the criteria of the law, then that's what my
What
obligation
jurisdiction
is.
are we?
I'm not going to answer this question, sir.
Oh, you're not going to answer the questions? Then I would like to know your status.
You don't ask the questions. I ask the questions. That's how.
Now we hit the philosophical standoff, common law versus statutory law. Hicks insists the court operates against the Constitution and declares himself governed only by common law. This is a familiar refrain, and a fatal one. Courts do not function on personal belief systems, they function on jurisdiction and statute. Judge Perkins doesn't chase the argument. She redirects him to court rules, because that's the reality of the forum he voluntarily entered. And here's the key contradiction: Hicks claims the court has no authority, yet repeatedly asks it for relief, dismissals, and trial dates. You can't reject jurisdiction while demanding its benefits. Viewers, this is where the ideology collapses under its own weight.
I don't have to find you in contempt. I don't want to do that. Okay? I'm giving you your opportunity to speak to the court through motions. You have your motion date already set. You can put all of that stuff in the motion, okay? And
why wasn't I notified about this case, this particular?
You are notified. You have it here. You have it there. That's why you zoomed in. All right, Mr. Hicks. All right, now I'm going to give you one last chance to speak, sir. Go ahead and well, before the other litigants come on.
And Your Honor, we're not on the record with Mr. Hicks.
No, we're not on the record.
We should be on the record with Mr. Hicks.
We're not. You don't have a court date today, sir.
I have a court date. I have the paper right in my hand. I have the paper right here in my hand.
In that case number, I told you your court date is, you have motion dates for that. You have a 721. State your name for the record, please, Mr. Hicks.
Albert Hicks.
Today is the date and time we'll call it set for a pre-trial date. I see here.
This is supposed to be the trial, excuse me, Your Honor. This is supposed to be the trial date.
It's supposed to be the pre-trial date, correct?
Absolutely.
Okay, Mr. Hicks, based on the nature of the allegation, the city's not going to give you an offer for this case. They want to see and speak with the officer, one being the gentleman you referred to off the record, Jonathan Rivas, and then there's another officer, Daniel Colgrove. Either one of those officers, they're both going to be.
Watch how Judge Perkins regains control here. Hicks starts resets the conversation, and narrows it to one question: trial date or not. This is courtroom management at its finest. Instead of allowing chaos to dominate the record, she forces structure back into the hearing. And Hicks' response, "Y'all make all the rules," is unintentionally revealing. Courts do make procedural rules.